It's been a busy and challenging year here at Lionsgate. The support and care that we felt from our community has been inspiring. And as we begin to turn the corner on this pandemic, I hope you're all optimistically looking towards the future. Before we begin, I want to take a really brief moment to give you an update on some of the incredible projects underway at Lionsgate. This spring, we launched and completed a $5 million project to establish an emergency mental health unit that will be built into our existing emergency department. Work's already begun on the critical care unit, which is expected to open in 2022. Very soon, we'll see the new medical and surgical center, Paul Myers Tower, take shape on our campus just off 13th Ave. This incredible building will have single patient rooms, operating rooms, and so much more, ensuring our North Shore residents can access state-of-the-art quality healthcare. There's so much going on and so much to look forward to. Some of you may wonder why we're hosting a session of this nature, and the truth is, it's a thank you to you, our friends of the foundation, and our loyal donors. We've done a series of webinars this past year, ranging from tax and estate planning to mental health. We simply want to provide you with information that you may not be able to access elsewhere. If you ever have any suggestions for future topics or areas of interest, please do let me know. There'll be an opportunity to provide feedback after the webinar, and I highly recommend you submit any questions or feedback you have. Now I will move on to the real reason you're here today. We are joined by Sally Dennis, who's a partner at Ferris LLP. Among many things, Sally's law practice includes planning for mental incapacity and estate planning. In addition, she also volunteers an incredible amount of her time as the chair of our Planned Giving Committee here at Lionsgate, and that's what's bringing you this presentation today. We are also joined by Tamara Vandenberg, who's the manager of client relations and risk management at Vancouver Coastal Health. Tamara has a pretty complex and vital role within our hospital. Essentially, staff and physicians reach out to her when they find themselves with issues involving patients who are unable to make their own healthcare decisions. Tamara sees firsthand the problems that arise when representation agreements are not in place, and she's going to speak to her experience and some of the things that she sees on a regular basis. Following the presentation, there will be time for questions. All you have to do to submit a question is hit the chat button at the bottom of your screen, and I'll bring it forward during the end, or if it fits correctly, I'll bring it forward during the presentation. Now I'm going to pass this proceedings over to Sally. Thank you.
Thank you, Carolyn. Good morning, everyone. Thank you for joining us. So what are we going to cover today? Well, we're going to explain to you what representation agreements are. We're going to explain to you what they are not. We're going to provide you with reasons why you should have one and give you some tips about what to include in your agreement and other provisions of the agreement should you decide to have one. And then we're going to turn things over to Tamara, who's going to talk about, in practice, what happens with representation agreements when they come into play in the hospital environment. So representation agreements are part of an overall personal planning regime that we would recommend everybody have. So personal planning is important so that you and only you control decisions that are going to be made about you in the future. It means that your family is involved directly rather than with the intervention of the government. And as a result, decisions can be made in an expedited, efficient way and as you want them to be made. All of this, of course, if you lose your independence because of your age or illness or some disability. The key concept behind all of this is consent. As each of you no doubt knows, whenever you go to the hospital or see your doctor or so on, you provide consent before any medical treatment is given to you or any procedure is undertaken. You must provide your consent. But what happens when you are no longer able to provide that consent? And this is where personal planning comes into play. All of the rules around consent are very important, and doctors are very, very aware of how important it is that you provide informed consent. And of course, then there's a gap in the system if you are not able to provide that consent yourself. So that's really what personal planning is all about. And representation agreements are just one element of that personal plan. This is specifically directed towards you having a say in your own care and living arrangements in the event that you are not able to provide consent to those kinds of things. So these are talking about things like where you're going to live, if you can no longer decide that yourself, how you're going to live, who you're going to spend time with, and more relevant to today's discussion, decisions about your health care. the kinds of procedures you're going to have performed upon you, the kind of treatment you're going to receive, the kind of medication you receive, the doctors you use, the other medical professionals, excuse me, whose assistance is engaged for you. And really the whole system is about supporting your decision-making as opposed to taking away your independence. The idea is to provide you with support when you need it the most. An important thing to understand is what a representation agreement is not. And this is where there can be quite a lot of confusion. So representation agreements, as I said, are all about lifestyle decisions and healthcare decisions. So a power of attorney is quite different from a representation agreement. A power of attorney is all about legal and financial affairs. So yes, the thing they have in common is that they're typically only used if you've lost the ability to do things yourself because of some kind of incapacity, but really they are limited to things like paying your bills, selling your home, buying things. It's legal stuff and financial stuff. It does not relate to medical decisions or decisions about where you're going to live. It's only about the financial and legal side of things. So if you show up at a hospital, or your relatives show up at the hospital with the power of attorney, allowing them to deal with your legal and financial matters, that's not going to help you when it comes to your health care. So something else a representation agreement is not, it's not a living will. That's a phrase you may have heard also. A living will is really an expression of your wishes with respect to your medical care, typically dealing with your end of life wishes. This is not a legally binding document. This is literally that. It's an expression of your wishes. So some people have some understanding of how you would prefer that you be treated. And the distinction there with a representation agreement is that a representation agreement does in fact have legal effect and legal binding implications. Another thing that's different with the representation agreement, it is not the same as adult guardianship or comiteeship. Now, this is really the last resort, the absolute last resort. If you have no personal planning in place and you lose capacity and decisions have to be made about where you're going to live or medical treatment you're going to receive, in effect, the court steps in to provide that consent, and the court will appoint somebody to make those decisions on your part. And the really alarming part about adult guardianship or comiteeship is that you then lose your legal identity. You no longer have any rights yourself. You effectively cease to exist as a person. The court and then your comity steps in. A representation agreement is really, as I said before, supplementing your own decision-making with somebody at your side to help you, not instead of you. So another distinction and something that needs to be clarified is what's a temporary substitute decision maker? Now, the representation agreement and this whole regime somewhat overlap, but this is really only in the default situation where there is no representation agreement, and it's only temporary and it's limited. So to give an example, if you don't have a representation agreement and your ability to provide consent is compromised and you need a medical procedure, not in an emergency context, then this regime will come into effect. Then your medical professionals will turn to whoever your closest relative is, and there's a list within the legislation as to who they ask first, and then they go down the list until they find a person who's there, who's willing to provide the consent for you, or is available to provide that consent for you. And I provide a list there, and it goes right down to really close friends, so long as these are people who've had some contact with you recently, so have some idea of what your wishes might be. But again, it's important to remember it is only temporary, and it is really, it's a default. DNR, I don't really need to explain, but it's the same kind of concept. These are instructions to your medical professionals. Another thing that's a part of people's personal planning often is what's called an advance directive. This is something that's recognized legally. And what it really is something that you address directly to your medical professionals, giving prior consent or refusal of consent to specific treatments. And so you're not appointing anybody to help you with this. This is you speaking directly in advance to your professionals about what some of your wishes are, and particularly the kinds of matters to which you do not provide consent. And those wishes must be followed by a medical professional within certain limits. And then there's a rather unusual animal called a Ulysses Agreement, which applies exclusively in the mental health arena, where people who are affected by medication will provide consent in one circumstance. And they want to make it clear that if their mental condition influences, excuse me, their decision making going forward, you are to ignore their changed wishes. So the idea is that when somebody is coherent and aware of what they wish to do as a result of medication, should they come off their medication and give contrary instructions, those instructions are to be ignored. So rather unusual, but sometimes gets confused with a representation agreement. Okay, so now we've talked about what it isn't. So now let's talk about the representations and what they are. And the first question is, who really should have one? Well, probably everyone, quite frankly. You have to be over 19 in order to be able to sign one. For all the reasons I just explained about having some say in who is going to provide consent for you going forward, if that's something that's important to you, yes, you should have a representation agreement. It's more critical for some people than others. If you have no immediate family, if you think back to what I was just saying about the substitute temporary decision-making regime, there is a default. But what if you don't have anybody on that list? So then there is nobody to provide that substitute consent. That's a situation in which clearly you should have a representation agreement in place. Another one is if your immediate family who would be on that list of substitute temporary decision makers, if you don't think they're going to follow your wishes or they're going to disagree about your wishes, then you should be choosing the one who has the authority to provide or withhold your consent. An example here would be somebody who, say, has 4 sons, and they all have very different views as to what your care should be in circumstances where you're not able to decide for yourself. You can just imagine all 4 would show up at the hospital and the doctor says, well, what do you want me to do? And they start arguing about what the appropriate care is and what their wishes are. What is a medical professional going to do in that instance? It puts them in a very difficult position. So whether you want to pick and choose between your children or not, I would encourage you to do that and do a representation agreement and choose the one person whose consent would override those who don't agree with it. Another example in which it would be important to have a representation agreement is if you really have some very specific wishes for your future care, whether it's where you're going to live or the medical care that you receive. And if those aren't well known to your family or they are particularly unusual, a representation agreement could help. An example here is one, actually a real example for me, where I had a lady who wanted a representation agreement that was limited in scope to her dental care. And her wishes there were for her representative to make sure that any dental care be given under full anesthetic. She was so terrified of dentists that even if she felt she had lost capacity to provide consent, she just couldn't bear the thought that that she would be conscious ever for any dental procedure. So she had a representation agreement appointing somebody to make sure those wishes were carried out. Not a typical example, but I'm sure you can all think of things where you have specific wishes for your care that you would really like to make sure are carried out. So the next thing is who would you choose as your representative? So the concept here is that you choose somebody and that person is called your representative and that person will be your advocate in the healthcare system. So who are you going to choose? It's not included on this slide, but obviously somebody that you trust. You are literally trusting this person with your life. So clearly somebody that you trust. But the legal rules are that it can in fact be anybody over 19. You can appoint a trust company or the public guardian and trustee for British Columbia. Typically it would of course be a close friend or family member. And you can have more than one representative. If you would prefer that there be sort of a committee of people making these decisions for you, absolutely can do that. I sometimes worry about the practicalities of that, where they're not able to all be together, or in fact they disagree. So I always prefer to be on a committee of just one person. That's how I get things done. So, but you can have more than one representative, and you can in fact be quite specific. You could name one person whose job it is to make decisions about where you're going to live, and somebody else is going to make decisions about your healthcare, because you might feel that some people are more qualified in one area or understand your wishes better in one area rather than another. So you can have more than one. And it's absolutely critical, in my opinion, that you have a backup person. There are all kinds of reasons why that first choice may not be able or willing to step in and be your representative when the time comes. Something could happen to them. They could pass on. They could themselves lose capacity. They may find themselves when the time comes, they simply can't do it. it's overwhelming, that they can't take on the responsibility, or maybe they've moved out of town and it's no longer practical. So please always appoint somebody who's that alternate backup person, just in case. Ideally more than one, because you just never know what's going to happen. But there are some rules about who cannot be a representative. You cannot choose your caregiver if that person is paid, nor can you have an employee at any care facility where you're living. So there are those rules, but otherwise you can choose whoever you trust the most. Ideally, somebody who is very familiar with your wishes, your principles, your faith, and other relevant matters. So what is their job? I've hinted at this already. Really, their job is to be your agent or your advocate in the healthcare system. They sort of step into your shoes when, for whatever reason, you're not able to take care of these matters yourself. They kind of become you and speak on your behalf to make sure that things happen in accordance with your wishes. And legally, what are the rules? Well, they are required to help you with their decisions. They are required to act in your best interest. They are required to follow the wishes as you have made known to them, to the extent that's practicable. They are required to consult with you about any decisions that are being made if you are still in a condition where that consultation would be meaningful. And then their job will be to provide consent or withhold consent as and when that comes up in the course of your medical treatment or procedures or decisions about your lifestyle and where you're going to live. So I provide some examples here. The kinds of decisions that are most typically come to the forefront will be decisions as you approach the end of your life. Do you want there to be ongoing treatment for your condition, or you're willing to consent to palliative care? And a critical one for a lot of people is more of a lifestyle decision about, never mind what, I want to stay at home. I don't care how much it costs. I do not want to go into a care facility. These are the kinds of things. If you're in a situation where you have been diagnosed with a particular illness and you know that there will be choices of treatment paths going forward, those again are the kinds of things you could put in a representation agreement to express your wishes as to whether you want to go treatment A or treatment B. So a lot of things here about what you can and cannot include, and I've already mentioned a lot of these. The most typical one, as I said, is the end of life wishes, the dying with dignity sort of language, and everybody has their own way of writing that. And I always encourage people to customize that as to what that means. A lot of people will say, when I no longer have any quality of life, I please withhold proactive care. What does that mean? Quality of life means something different to everybody. And so we do encourage people to explain that either in the agreement itself or in some other written form that you would provide to your representative. And another important thing for people are the things that I do not want done to me. So if as a result of your faith or culture, there are particular things that you are adamant you do not want, such as blood transfusions, for example, those are the kinds of things you put in the agreement, just in case that gets overlooked, and the type of care that you want to have. And people will often talk about things like whether they're willing to go into drug trials or whether they'd try something experimental or controversial or more conventional care. These are all things that you can include in your representation agreement if you have any views one way or the other. You don't have to include any of these things in your agreement. The important thing is to appoint a representative, and then you trust that person to take care of things. But the more specific you can be, the more likely your wishes are to be carried out, of course. A very important and fortunate a limitation on what we can include in representation agreements is you cannot provide advance consent to assisted dying. This is still something that is not permitted, although the laws have been changing recently. They still require that you have full capacity to provide consent to be admitted into that program. The requirement for a second consent immediately prior to the treatment being administered has been waived in very limited circumstances. But the important thing is that you have to be completely coherent and have full capacity to provide that consent at the beginning of that process. You cannot, in a representation agreement, say, when that time comes, I allow you, my representative, to provide that consent on my behalf. That is not permitted. Some other limits on what a representation agreement can and cannot achieve. Nothing is ever a magic bullet. Should you have expressed wishes that are simply not practical, or are contrary to sound clinical judgment. And a medical professional just, your medical professionals, of course, have a duty of care to you to do the best that's for you. And if they believe that the representative is providing instructions that are contrary to what they would diagnose or prescribe or do, they are not required to follow those instructions. This is something that I have no doubt that Tamara will mention in her part of this presentation. So, it's again, the important thing that comes up is that how far must a medical professional go to find out whether you even have appointed a representative? Again, there are limits on this. There's no magic system here where the fact you've signed a representation agreement means that your representative will be there making those decisions for you. There's no guarantee that that will happen. Your medical professionals have to know that there is a representation agreement. They have to be able to find your representative. So it's not bulletproof, this system. It's absolutely better than not having anything at all, signing a representation agreement, but you have to understand that there are some weaknesses in the system. It's not perfect. So there are, to complicate things just a little bit here, there are two kinds of representation agreement, and you may have heard of this, and it can be very confusing because one is called the standard agreement, and I think it's anything but standard, and then there's the other one. So I'm going to call the other one the normal representation agreement, and this is the one that I would think that most of us would consider signing. A normal representation agreement is one that you would sign when you're fully capable of doing it, and it's very broad. It covers everything that your representative might consider necessary in relation to your personal health or care or healthcare. It does not give your representative any authority over your financial affairs. So it's everything about personal care and healthcare. It's very broad, and you are fully capable when you sign it. Now, the other kind is one that permits people whose competency is already compromised. So if somebody already has a disability or is already, for example, has Alzheimer's or other signs of dementia, it is possible still to sign a representation agreement, but it's a little different. It's more narrow in scope, and there are more limited things that your representative can do on your behalf. But the good thing about these is that the representative can then handle your day-to-day routine financial affairs. Because if you're in that condition, you probably can't sign a power of attorney anymore to deal with legal and financial matters. So this other kind of representation agreement does allow your representative to pay your bills and deal with day-to-day matters. There are other restrictions, though, are they're not allowed to get involved with your end-of-life decisions. They're not allowed to deal with sort of major or experimental treatments or surgery and so on. So they're sort of lower impact decision making, but at least they can have some involvement in your ongoing care. And then there's this animal called a monitor that has to be appointed. It's not an animal, of course, it's a person. But the role of the monitor is to kind of supervise this person. The whole concept being here that you're already vulnerable, you're already compromised, and so you need a sort of second pair of eyes to make sure you're not being taken advantage of. So that's the other kind of representation agreement. Most of what I've been talking about here today has been what I call the normal representation agreement. So the formalities for this, it's actually very easy to do a representation agreement. The really good news is you don't need a lawyer to do one, which is really good news. Most people don't want to have to see a lawyer, and I understand that. So you don't need a lawyer to sign one of these agreements. And you can find the form of agreement. There's a prescribed suggested form that the government has on its website. If you search under Representation Agreement Act regulations, you will find the form there. And there's also a really helpful website, the NIDAS website, that deals with all of these things to do with personal planning and incapacity planning, including representation agreements. It's a really very, very useful website. I strongly encourage it. And they have a form of agreement there that you can take a look at. So the only rules really with it are that you have to sign in front of two witnesses. And for obvious reasons, the person you're appointing as the representative can't be one of those witnesses or people closely related to that person. And the witness has to be 19. You can just sign the agreement, and two people, it can be two neighbors or whatever, witness it, then it's valid. If in fact you do go to see a lawyer to get one of these done, then you just need the one signature of the lawyer or notary. The representative does not have to sign the agreement at the time. However, they must sign it before they can actually rely on it. And there are no witness requirements for the representative signature. So that it's the whole system has been set up to make it easy for you to do this and to encourage you to have representation agreements. An important thing that often, of course, you'll be asked is, what if I change my mind? What if I don't like that person anymore? What if they just said something outrageous about what they're going to do to me if I get sick? Yes, you can change your mind. You can absolutely revise it. You can do a new agreement, changing some of the details in it, or changing the representative you have selected, or you can revoke it. And that is, quite frankly, rip it up, rip the agreement up and do a new one. If you've already told the representative that they are going to be a representative, you have to give them notice that you have done that. But other than that, it's very easy. And I'm not joking when I say rip up the agreement. If you do a series of agreements, like in consecutive years, please rip up the previous one so there's no confusion about which one your doctors can rely on. And there are also some legal events pursuant to which then the agreement just ends. If you've appointed your spouse as your representative and you get divorced, well, that's the end of the agreement. If your representative, him or herself, also loses capacity, the agreement terminates. Again, not if you've appointed a backup person though, so it's fine. Okay, so that's all the legal stuff. Those are all the legal parameters and explanations as to what a representation agreement is and how you sign one. But how do they really work? And this is far more important, quite frankly, and particularly as a lawyer, very often I'll have people sign an agreement and off they go happily with their representation agreement in their pocket. And I often think, well, but now what happens? What happens when somebody has lost the ability to provide consent and they go and they need to see a doctor or they show up at the hospital? Over to you, Tamara, you're going to explain that.
Thanks, Sally, and thanks everyone for joining in today. As Carolyn mentioned, I work in the Client Relations and Risk Management Department here at BCH, and I act as a resource to staff to identify, assess, and mitigate the risk to the patients we serve. So in my role, I have a lot of experience with situations involving representation agreements. Excuse me. So I thought I would start off by running through some of the benefits of having a rep agreement with you, and then provide you with some examples from my experience, and then leave you with some recommendations. So some of the benefits of having a representation agreement. It really helps minimize the conflict amongst family members if you have one appointed person to make those healthcare decisions. Sometimes we come across and the families are arguing because they have different ideas about care about the patient. So it really helps to have that one point person who can make those healthcare decisions. As well, it really helps reduce stress amongst the care team. So for example, when you do have families with having disagreements about care, the care team's trying to manage the care of the patient, and it really gets quite stressful for them if they're also having to manage the family as well. So again, having a representation agreement really helps to reduce that stress. It also helps in making crucial healthcare decisions, in assisting in making crucial healthcare decisions. It also permits healthcare providers to share healthcare information. So for example, if they're wanting to share the status of a patient with family members, it's really, again, good to have one point person that they can communicate with, and that point person can then communicate with the rest of the family. It's quite difficult for staff if there's several members of the family wanting information. It's much better to be able to have that point person. And as I said, the staff can then share that information with that representative. And representatives can also receive that communication. As well, if for some reason family members or friends are not happy with the care the patient has received, they can lodge a formal complaint with our patient care quality office. However, the patient care quality office does require appropriate consent in order to investigate and respond to the complainant. And that's where the representative would come in as well. If the patient is not capable to give that consent, then the representative would be giving that consent, and they would also be needing to provide the documentation for proof that they are the representative. So I thought I'd move on to some examples of situations we've come across in the hospital here. So what happens when a patient admitted to Lionsgate who's incapable of making their own healthcare decisions? Well, if the patient arrives and requires urgent or emergent care, for example, life-saving measures, then the healthcare provider does not require consent. And there's other examples of those type of care that can be provided without consent in the Healthcare Consent and Facilities Admission Act. If consent is required, staff will make every reasonable attempt to locate the representative. They try to get a hold of the next of kin, or if there's an emergency contact. And then, as I said, they make every attempt to determine who the representative is. The next slide, please. So what if there's no representation agreement and you've got family that have conflicting views about the care of the loved one? So for example, if you have siblings arguing over their different ideas about the care of their parent, and there's no rep agreement, it does make it quite difficult for the care team. The care team would then need to assign a temporary decision maker. So they would choose the first qualified on that list, as Sally had mentioned before, contained in the Healthcare Consent Act. There's a list of people who can be qualified as the representative. If there were equally qualified substitute decision makers, for example, several children, as Sally also mentioned, perhaps 4 sons, then the team would actually work with the family to try and come up with a consensus as to who would make the best temporary decision maker. Again, it would be a lot easier if somebody came in with a representation agreement, as again, this takes time and there's usually several family meetings to determine who that temporary substitute decision maker. Also in these situations, we do tend to loop in our social work department, a social worker for that unit, as sometimes there tend to be underlying reasons why there's these conflicting views. So there's definitely a lot of family meetings. Social work almost always gets pulled into these situations. We'll run over another example. Okay, so what happens when the representative wants to pursue medical interventions and treatments that the care team disagrees with? So if the medical interventions and treatments that the representative want to have happen is determined by the healthcare team to be non-beneficial, meaning it's medically inappropriate or ineffective, there's no obligation to offer that care. This decision would be communicated to the representative. And again, there's a lot of family meetings that take place. Social work is pulled in. The representative can also ask for a second opinion. As well, we have guidelines, internal guidelines to deal with these processes. So I thought I'd run through some of the recommendations now. So for recommendations, I highly recommend you pick someone who will act in your best interests, who will act according to your wishes, and make sure that person is really clear about your wishes. Try to only have one representative, because we have had situations where there's 2 representatives. And again, it makes it very difficult for the care team if there's 2 representatives who have differing views. Really make sure as well that the person understands their role and responsibilities that come with being a representative, as we've had situations where representatives have removed themselves because they've been quite overwhelmed when they found out what the roles and responsibilities are. So that is really, really important, to just really have a very thorough conversation when you're planning with the representative you're planning on appointing, as it's really important that they understand what their role and responsibilities are. And to end, I would be very grateful when people come in with representation agreements. It just makes it so much easier on our teams to be able to have decisions made as quickly as possible. Thank you. I'll turn it over to Carolyn for questions.
Great, thank you so much, Tamara and Sally. We now have the opportunity to answer some of your questions. I've seen a few come in and we will address those. And if you have any others, please just submit them with the chat button at the bottom of your screen and we will hopefully be able to get to them. The first one that came in is probably for Sally. Is a representation agreement written in BC acceptable in all other provinces? And I suppose that extends to elsewhere in the world.
Well, that's a really good question. I'm glad somebody asked it. And unfortunately, I don't have a complete answer to that. As a general comment, because the law of consent is a provincial law and representation agreements are recognized by British Columbia legislation, they clearly are effective within British Columbia, but they are not required to be recognized in any jurisdiction other than British Columbia. Now, the reality is, I think that a lot of other jurisdictions, depending on what you're talking about, would have similar laws that would say if you've expressed your wishes, then the medical professionals will take those into account with their care, but they would not necessarily be required to accept the responsibility and the authority of your representative as your agent, because it's provincial legislation. And as far as I'm aware, no other jurisdiction has specifically said BC representation agreements will be acknowledged in this jurisdiction. If a representation agreement happens to be very similar to a regime that's in place in that other location, then they might manage to qualify. But on the face of it, no, they would not be operative. So my advice always to people who spend a significant amount of time outside the province, for example, people who go to Arizona for the winter or whatever, is to inquire locally as to what the requirements are for the equivalent in that jurisdiction. And there's also the practical thing is that possibly if you are somewhere else and you've chosen a representative who's here in BC, you may want to have somebody in that jurisdiction at hand locally anyway.
Thank you, Sally. We have a follow-up, which is what happens if you have a representative, but they're not reachable or they're traveling or something like that? That's probably for both Sally and Tamara. What happens if you've got a patient who comes in with a rep agreement, but you can't contact the representative?
Well, I'll go first, Tamara, if that's okay. This is why it really is important to have that alternate person. And you could specify then that in the agreement that if your first choice is not available, not so much doesn't have capacity or isn't willing to act, but is not available and cannot be reached, then a different person can step in as your representative. I think it's critical to do that because, yeah, otherwise you're going to be stuck. And Tamara, I believe I'm right in saying that it's okay if somebody's just on the phone or available digitally as
oh yeah, we have so much technology these days. Yeah, they can definitely contact them via phone or digitally, for sure. We've had that happen several times here.
But I think if you do choose a representative who does tend to go incommunicado for a while, who travels a lot or whatever, is not particularly reliable at checking emails or picking up their phone, I can think of more than one of my children, for example, who wouldn't pick up the phone. Either choose somebody else or have that backup. And the trigger for the backup person's authority would be if you've tried, say, 3 times to contact my first choice and they're not available, then the second person can step up. Yeah.
All right, we have a couple that are on the same kind of path. Essentially, can the agreement be filed with their doctor? Do they have to bring it in paper? What's the process tomorrow once they have that document of presenting it within the hospital and making sure that it goes to the right people? Do they carry it around in their wallet?
Well, so yes, if the representative does arrive and they need to be having the document in hand, and then we would get a copy of that to have on file when the patient's in hospital. We would require that paper copy. So if they could arrive with that. I mean, if they don't arrive with the patient, and then the representative is contacted, yeah, they would be great for them to be coming in with that copy, because we would require that.
Can it be filed with the doctor or at Lionsgate prior to a patient being?
No, we wouldn't file it here prior. It's if a patient comes in, and then we're contacting the rep, and then they would come in with the representation agreement. But it's not something we would be filing beforehand if they had a representation agreement put together, and then they wouldn't automatically file it with Lionsgate. No.
Okay. Do you know if they ever file it with a physician, their primary care physician, before? Is that something that Lionsgate would do, is reach out to their physician, or it's really up to the individual to bring it in?
I think it's up to the individual. Yeah.
Okay.
Yeah, I always advise people to provide a copy to their family doctor in the hope that somehow that finds its way through the system. But this is an area that's a bit of a cause of concern. There's no sort of official registry where the hospitals would be required, or the health authority would be required to check whether a person has a representation agreement. It would be great if there were such a system. The one thing that I do to try to help with this is actually send it in digital form with the permission of my client, of course, to the representative, so that they hopefully have it on their phone or somewhere where they can access it, as opposed to a paper copy, that they've got it somewhere accessible. And I understand that that would be acceptable to the hospital, correct, Mara?
Yes, it would be, yeah.
So when someone has presented a representation agreement at Lionsgate, is it filed within a system where it would be accessed again in the
It's
future
scanned
if
into their
necessary?
health record. It's scanned into their health record, yes.
Okay, thank you. Someone's asked what happens if they appoint two representatives, I think probably children, and they disagree on the care.
So, so I can answer that. It's had that experience before. So if they disagree with the care, again, the team would be meeting with the children, as well as social work would be involved. And they try and work out to see if they would come to agreement, but it would be based on what the patient's wishes were. So again, it's great to be very clear when you do the representation agreement, to be clear on what the wishes are, because then the team would be looking at what the patient's wishes were, and then they would be working with those representatives to ensure that those wishes are met.
Great. I have only one more question, so if there's any more, please submit them, which I see are coming in. But what happens if the person I choose is clearly not acting in my best interests?
I can answer that one because we've had experience with that one. So if a healthcare provider is concerned that a representative is not acting in the best interest, our department gets contacted, risk management. There's a process then followed to remove the representative. They need to be informed in writing, and there's quite a process involved in that. And then they could go to an alternative representative, but there's definitely a process for that. As well, Public Guardian and Trustee's Office, they also has the authority to investigate and intervene when there's an objection, sorry, to a representation agreement. And as well, all suspected abuse or neglect by a representative, they must be reported to designated responder. So the care team would be involved right away. Social work would be involved right away if it's clear that they're not acting in the patient's best interest.
Perfect, thank you. I think this is probably for Sally. Goes back to some things you were speaking about, but is it customary to compensate the representative for long-term care responsibilities? And if so, on what basis?
I would say it's not customary. I mean, I would say in the vast majority of cases, these are close family members, friends who do it out of love and affection, as opposed to being compensated. They can be compensated, but I'd say it's quite unusual. You know, when trust companies get appointed, which is also unusual, but it does happen, they clearly get paid a fee for doing so. But I would say it is not customary. If that were something that you wanted to do, I would think that the more common thing would be that you would charge an hourly rate for the care. I don't know. I think most people, what they do is they don't provide for a fee or compensation, and they leave the person a gift in their will.
All right. Thank you. I think that wraps up all of the questions that have been submitted. So I think we will wrap it up here. I first off want to thank both Tamara and Sally. I just had one more question, if we can take a moment to answer it. Does the representative agreement need to be a legal document, or can they just cut and paste an existing one?
I think so long as it's witnessed properly with the two witnesses, if it is a bit of a cut and paste as opposed to something that's custom drafted, I think it should be okay. I think that if I were on the receiving end of that, I'd be a bit worried about whether somebody has fraudulently inserted something that shouldn't be there. It would just look a little bit suspicious. So I think it might raise some concerns if it's clearly, that a paragraph is being, sort of cut and paste from something else and it doesn't really fit in there. You'd wonder whether somebody had done that after the fact, as opposed to was the actually is in fact reflective of the actual wishes. So it could raise those kinds of abuse questions, but on the face of it, so long as it's witnessed, and there's be no reason why you couldn't provide an agreement that way. As I said, you don't need a lawyer to create one.
There's one more question. I'll try and present it quickly, but what happens when the named person, so the representative, will not make the decision in the hospital? So if they choose not to, I suppose, and the only other person, the executor, legally can't. Tamara, maybe that one's for you.
I was going to say,
Yeah.
Tamara, I think this
Yeah,
one's
for sure. Yeah. So I actually haven't, I think I haven't come across a situation where it's continued that they haven't made the decision. Again, there's not to keep harping on it, but there is meetings that would take place. Social work would be involved, speaking to the representative. Again, there's a lot of times there's underlying reasons for the conflict, for why they're not wanting to make a decision. And in my experience, it has been worked out. I haven't come across an experience that I've had where they haven't been able to make the decision.
I'm going to take one more, and then we will go back to wrapping it up. But do they need an advanced care plan as well as a representation agreement?
Well, I would say that the representation agreement is part of an advanced care plan. It's just one component of the many things I think that people should be considering putting in place.
Perfect. All right. So I am going to be sending out this presentation as well as a copy of the video to everyone that has attended and signed up. I just want to say thank you both to Tamara and Sally for putting so much time and effort into this and for being here today and providing all of this information to everyone. I hope it has been useful. If you have any additional questions, please do follow up with myself or Tamara or Sally. We're happy to help. I hope that this has made you realize that perhaps a representation agreement is in your future, your hopefully long future. And I will be sending out a survey at the end of this as well, and as well as all of the resources in an email. So please do provide feedback. If there's anything, any other topics of interest, please do let us know. We're happy to bring them to you in the same format. And I wish you all well. Thank you, Tamara. Thank you, Sally. And thank you everyone for joining us today. Take care.